Alrighty, this week's People News. One more time at it. Not attorney, not giving legal advice. Educational purposes only. Never look straight forward, always look around you, be able to protect yourself by any means necessary. Alright, so we're back into sovereignty and living. Okay? And again, the reason why I like his videos is because he follows through. He fights these things directly into court. He don't have no attorney and all these kind of things. So, any man or woman that stands on their rights and willing to butt heads, you know, has got my respect. Okay? And this is an interesting one. Let's proceed forward. Don't know what I'm going to call this video just yet.
So I did a notice of constitutional challenge into my case. And so this is a brief that I attached to it. The Court of Appeals finally sent me their letter, because whenever you do an appeal, they send you a letter and say the filing fee, you have to pay the filing fee, you have to, they tell you to do some things so that, and then what they'll do eventually is send you a scheduling order. And so they finally sent me that letter, and so now I have to prepare my response here this weekend. So this is a brief in support of the Notice of Constitutional Challenge pursuant to your Code of Law Rule 5. Comes now demandants providing notice to the bought and paid for clerks masquerading as judges in this inferior legislative court and their executive branch congressional handlers in the District of Columbia that their 1871 corporation at 16 Stat 419 domiciled in the District of Columbia and its minor estate scam are violations of the organic laws as follows. So there's 4 organic laws for the United States of America. We've been covering this in other YouTube videos. And so I would recommend you, because we've only gone through the Declaration of Independence and we started going through the Articles of Confederation. And so there's 4 organic laws. And if you go to the Office of Law Revision Council, which is a U.S. House of Representatives website, they talk about this. Okay, and this is important because this is the real law. Okay. The Articles of Confederation and Perpetual Union, 1781, the Northwest Ordinance, 1787, and this Constitution for the United States of America, 1787. The Northwest Ordinance was published by Congress or enacted by Congress 3 months prior to the Constitution. So, and the reason they did the Northwest Ordinance is because in the Definitive Treaty of Peace of 1783, the King of England granted Congress huge tract of land. It's basically the United States had all the territory south of the Great Lakes and the St. Lawrence River, to the west to the Mississippi River, and then south of that to the Ohio River Valley. So all that territory, so there's like about 5 states in that area right now, and that wasn't part of any of the original colonies. And so they had to do a Northwest Ordinance which defines federal jurisdiction in federal territory, and that's really important because Texas, for example, because Texas is under a military occupation, we're federal territory, and so it defines the nature of federal jurisdiction. Even though it's called a state, it's not a state. As it's actually comparable to the original 13 states, but because of the Civil War, it's questionable as to whether they still have military occupation here. They have it in Arizona. They actually have it because of the martial law that was imposed during the Civil War, and that martial law was imposed everywhere. So the District of Columbia 1871 Municipal Corporation is a violation of the organic laws because it's Roman law from the Vatican. Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law, to distinguish it from the law of nature and from international law. So again, that's why these kangaroo courts, or they're all kangaroo courts, they're everywhere, because they're Roman law, which violates Article 1 of the amendment, which requires Congress shall make no law respecting an establishment of religion. And so they're bringing this Roman law from the Vatican on the land of America. And is bringing the Vatican's Roman law into the land of America, which uses fraud, deception to supersede and replace common law. And this is, there's no common law offenses against the United States, only those acts which Congress has forbidden, with penalties for disobedience of its command or crimes. And under Texas law, no act or omission is a crime unless made so by statute. The legislature may create an offense under the same enactment, provide exceptions to its application, as found in the Causes and Necessities for Taking Up Arms, 1775. Statutes have been passed extending courts of admiralty and vice admiralty far beyond their ancient limits, for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the courts of common law and instead thereof to publish and order the use and exercise of the law martial. So that's important. So it supersedes and replaces common law. That's why they don't, they'll sit there, their codes say, the common law applies, insofar as inconsistent with, they put all this lawyer language in there. And it's also talked about some of the reasons for the separation from the tyrant, the organic law, the Declaration of Independence, 1776. He's confined with others who subject us to a jurisdiction foreign to our Constitution, unacknowledged by our laws, giving his assent to their acts of pretended legislation, for transporting us beyond seas to be tried for pretended offenses. That's talking directly about the minor estate. For imposing taxes on us without our consent, for depriving us in many cases of the benefits of trial by jury, for taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our governments. He's abdicated government here by declaring us out of his protection and waging war against us. And that's what every court case is, warfare. Okay, you got to understand that. That's Roman law. That's what Roman law is all about. It's warfare. Because common law is
collateral attack. Oh, sorry, Glenn. I like a collateral attack because they cut off your commerce.
Well, it's not my commerce. I mean, I can make a contract with somebody without entering into commerce. Okay, commerce is very specific definition. You have to enter into international law to do commerce. Okay, so you're kind of confused there, and you have to be careful how you use your words because they use it against you. Remember, what do they tell you? Anything you say can or will be used against you in a court of law. So you have to be careful about what you say. Because common law is the law of the land, which has always been here. And this is Hale versus Hinkle. His rights are such as existed by the law of the land long antecedent to the organization of the state and can only be taken from him by due process of law and in accordance with the Constitution. And it is full of fraud and deception, which is the same reason why we took up arms against the Vatican's tyrant for all the grievances listed in the organic law of the Declaration of Independence, 1776. The minor estate at 31 Stat 363.6, that the County of Montague and their Vatican's bar members and their Vatican's bought and paid for clerks masquerading as judges have assaulted the demandant with is also a violation of the organic laws under Article 1 and Amendment, which requires Congress shall make no law respecting an establishment of religion. The minor estate was created by the Vatican. And this is Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of Mort Main. Yet still it was found difficult to set bounds to ecclesiastical ingenuity. That's the Roman cult, folks. For when they were driven out of all their former holes, they devised a new method of conveyance, by which lands were granted not to themselves directly, but to nominal fiefs, to the use of the religious houses, use being usufruct, thus distinguishing between the possession and the use, and receiving the actual profits, while the season of the land remained in the nominal fief, which was held by the courts of equity, then under the direction of the clergy. That's the Roman cult, folks. Isn't that convenient, eh? The clergy gets to decide whether it's wrong or right. To be bound in
So If you wonder where the Republic is this possible? Especially in this day and age where all the trickery of words has been misleading everybody.
To account to the Sestake use for the rents and emoluments of the estate. That's taxes, folks. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. And by the Vatican's tyrant with the Sestake V Act of 1666, Chapter 11, 1819, which was for land titles, which was brought into America with the Code of Law for the District of Columbia at 31 Stat 1432, where it says, the legal estate to be in the Sestake use, which is talking about land titles. And a use is short for usufruct under Roman law. These things which perish by capitis diminutio, or which kind are a usufruct, an obligation of services on the part of a freeman contracted by oaths, and matters enforceable by a statutable action. And this is taken from the commentaries of Gaius, the Rules of Ulpian, translated with notes, 1874. Which is a type of a trust, and a U.S. citizen minor estate entity is a taxpayer. Every taxpayer is a Sestake trust having sufficient interest in preventing abuse of the trust to be recognized in the field of this court's prerogative jurisdiction. A citizen of the United States is a civilly dead entity operating as co-trustee and co-beneficiary of the public charitable trust. The constructive Sestake Trust of U.S. Inc. under the 14th Amendment, which upholds the debt of the USA and U.S. Inc., and that's taken from Congressional Record, June 13, 1967, pages 156-41 to 156-46. Okay, so that's a summary of 5 pages of a Congressional Record. So it's not, you won't find it in there, but if you read those 5 pages, it's essentially saying that.
And furthermore, when you read it, right, it means you are subject to the federal government. Subject. So, the 13th Amendment does not exist anymore. Right? Just saying. According to this, the 13th Amendment does not exist. It's null and void.
Vatican's minor estate is also talked about as some of the reasons for the separation from the Vatican's tyrant and the organic law of the Declaration of Independence. And this is, again, the Declaration of Independence. He's combined with others to subject us to a jurisdiction foreign to our Constitution, unacknowledged by our laws, giving his assent to their acts of pretended legislation, for transporting us beyond seas to be tried for pretended offenses.
All right. I'm going to stop it right there because it's going into another page and I don't want to disrupt. Again, this is live. I don't know if it's going to appear again. So this is my purpose of my research. And since it's on the public view, there you guys go. Okay. However, this is the reason why I'm doing this, because I want to go through this over and over and over. All right. Education, y'all. Education. All right. Find out what happened. Where's our republic? All right. By the way, I need to do thumbs up. Till next time. Bye, y'all.